TKPA Good afternoon, ladies and gentlemen, and good morning to Professor Szabo. Is my
Good morning.
pronunciation is correct for your name?
Yes.
Okay, thank you. Before I start the lecture, let me introduce myself. My name is Enrico. I am one of the international staff for Postgraduate School Universitas Erlangga, and I'll be your moderator for today's lecture. And on behalf of our director of Postgraduate School, I would like to say thank you to you, Professor Szabo, for your time and for your willingness to conduct this public lecture. I would like also to thank you on behalf of Dr. Rosa. She would like to thank you also for your time to join with our session. And I hope this is also from Dr. Rosa. Will be your first for many lecture here at Postgraduate School Universitas Erlangga. And next year, we are hoping to welcome you physically in our university, Professor Szabo. Yeah. Okay, shall we start, Professor?
Yes, can you clarify the time frame of the lecture? What time is allocated?
Okay, so usually we have 60 minutes for the lecture. It's divided into two parts. The first one will be the lecture session, usually take around 45 minutes. And then we'll be follow up with a Q&A session for 10 to 15 minutes. Is that okay for you, Professor Szabo?
Perfect. Yes.
Perfect. Okay. Once again, thank you. And let me briefly introduce you to the audience before we start your plenary session. Okay. Good afternoon, ladies and gentlemen. Welcome to our 57th edition for the guest lecture here at Postgraduate School Universitas Erlangga. For today's lecture, we are joined by Professor Szabo Zsolt. Professor Szabo Zsolt is Associate Professor from Department of Constitutional Law, Faculty of Law, Carol Gaspar University of the Reformed Church in Hungary. And for our today lecture, we will talk and discuss about judicial control of parliamentary procedure. So without further ado, Professor Szabo, the Zoom is yours. Thank you.
Thank you very much for the invitation and for the kind introduction. Ladies and gentlemen, dear colleagues, I prepared some slides and I would like to share these slides with you. So let me, yes, share screen. This is it. All right. Let me ask you if you can see my opening slide now.
Yes, right now we are in the second slide, Professor.
And did it change now?
Not yet, Prof. Wait.
Okay. So is this, can you see now the contents of my lecture, the 4 points on the slide?
Yes, we can see it.
Okay, okay. Perfect. And now I changed the slide and I can see, and you can see now the building of the university. Is that correct?
Not yet, Prof. Still in the content slides.
Okay, I don't know how to change
now
the
we can
slide.
see the building.
Okay, okay, perfect, perfect. Very nice.
Yeah.
And can you see now?
Yes, yes, we can see it now.
And can you see the contents now?
Not yet, Prof. Still in the building slide. I believe there is a yeah.
Okay, but at least you can see it. You can see the building of the University of Public Service right now. This is my other affiliation. I just wanted to show you a nice image in Budapest from our autumn. And let me jump to the second slide. You can see now, I hope, the contents.
Yes, we can see it now.
Perfect, perfect. So the system is working. Today, I would like to talk about a very interesting topic. I think it is very interesting, but it's not very often discussed. We look behind the scenes of democratic institutions, especially the parliament. Because mostly when we talk about parliament, we think about the parliament's relation to the judiciary or the parliament's relation to the executive. We think about the functions, the voting, the passage of the laws, but the rules of procedure, which is behind the scenes, is not very often discussed and is kind of hidden. But I will argue that rules of procedure are very important pieces of legislation. I will show you some kind of legal nature. I will make groups of rules of procedure, because in various jurisdictions, in various countries, they have various legal forms also. And after this, there is nothing else I want to do that to draw a map of possible forums of judicial disputes of parliamentary procedure. Because these parliamentary rules of internal procedure certainly have some criteria. And this criteria is very often unwritten, but sometimes there are also written criteria in constitutions. And I would like to show you some of them. And of course, the question is open whether or not this criteria is justiciable, whether or not you can go to any forum if these criteria are not respected. And at the end, I will draw some conclusions also. So on my third slide, hopefully you can see it, about the rules of procedure. If not, then please give me a sign. So the rules of procedure are in the heart of parliamentary and national sovereignty. They are under the control of the majority, but they protect the rights of the minority. Think about a parliamentary majority, whether it is 50% or 60 or 70 or 80%. Of course, the rules need to be approved by the majority of the parliament, but nevertheless, they should respect the rights of the minority. The main rule of the democracy everywhere in the world is that the majority decides and the minority should be heard. This is maybe the very brief essence of democracy. The majority decides, also in the society, but the minority should be able to argue, should be able to tell the arguments and the possibly dissenting opinions. My third criteria is that rules of procedure should be fair. Now, what does it mean for the rules of procedure to be fair? What are fair procedures? I think there is no very strict legal definition to that. So it is very much the practice and the country by country practice shows which is fairer, which is not. But the main criteria of fairness is that every member should be respected, members' rights should be respected, and the minority should be heard. Rules of procedure are somewhere halfway between law and politics. They are legal rules of a political game. And very often, the players create their own rules. It is like in sport, if the football players would be eligible to discuss and change their rules of the game. Of course, it's better if we separate the rule setters, the rule makers, the lawmakers, and the players. But in terms of parliament, it is not possible. Everywhere in the world, the parliament is responsible for creating the rules of procedure by the political majority. Of course, these are not only legal rules. These have to take into account the political dynamics. And lastly, rules of procedure are internal constitutions of parliament. They constitute the internal bodies. They constitute the guiding principles of the parliamentary functions. And if you look into the rules of procedures of any countries, you find three major topics in them. They regulate the procedural order. I mean, they regulate the sequence of the different parliamentary activities. They draw the steps, step-by-step procedures of lawmaking, for example. Secondly, they describe the organization of the parliament. And thirdly, they have some rules, longer or shorter rules on minority rights, what the minority can do to tell their opinion, to project it to the audience, to the general public. And this is what rules of procedures are about. The FAIR rules are important because there are several research results arguing that institutional settings heavily influence policy outcomes. If the rules of procedures are not fair, then also the results of parliamentary activities can likely not be fair as well. Of course, there is no guarantee that fair procedures guarantee fair results, fair laws. But if the internal rules are not fair, then the laws, the statutes the parliament adopts might also not be fair. Fair procedures are needed in a democracy under rule of law because all members should be given the right to participate in parliamentary debates. And thirdly, the control of parliamentary time and agenda is a key issue in politics. Those who have access to parliamentary time and those who can control the parliamentary agenda are in control of the whole political governmental process. And they can produce laws according to their political agenda. And of course, parliaments have to be able to create laws. Of course, it's important to pass legislation. And it's very destructive if oppositions, if parliamentary minorities stop or block parliamentary legislation. It should not be allowed. But there should be found a balance between blocking legislation by the minorities and between giving them the fair rights to speak up and continue participating in the debate. The sovereignty of parliament is a very ancient fundament of the British law, of the English common law. And this is spread all over the world in the meantime. It says that all parliaments are autonomous in creating their own internal rules. No other bodies outside of parliament have the right to intervene in the creation of parliamentary rules. Parliaments, houses, have the right to determine their own proceedings, including organization, structure, procedures, allocation of time, as you can see it on my slide, disciplinary measures, or protection for external influence. There is another principle which is a little bit against this sovereignty of parliament, and this is the sovereignty of the constitution, based firstly on the US Constitution, but in the continent, in the meantime, in continental Europe, we have the German constitution. The German constitutional system is very much based on the sovereignty of the constitution. And this principle says that it is necessary to protect the constitution at all costs, even protect the constitution against the parliament if needed. And some legal remedy is important against unlawful acts or abusive majorities in parliament. And these two principles, the sovereignty of parliament and the sovereignty of constitution, are opposing each other. Sometimes they go against each other, and you have to balance, you have to choose one. You are either building up your constitutional system on the sovereignty of parliament, saying that everything which the parliament does is a holy thing and cannot be touched and cannot be struck down at any forum outside parliament. Or you say that the constitution is first and you have to protect the constitution and constitutional principles, and you have to defend it on a constitutional court. Now, in the United Kingdom, there is no written constitution, so it is not possible to protect the sovereignty of parliament elsewhere. The parliament protects itself. And this is why the sovereignty of the constitution is not a guiding principle in the UK, but it is in continental Europe, and also in Hungary, this is the case. Okay, now I'm going to the next slide. Can you see these quotations from constitutions right now? Please give me a short signal.
We can see it, Prof.
Thank you very much. So the general rule which I show here is the sovereignty of parliament. In the Article 9 of Bill of Rights, it is said that the freedom of speech or the debates or proceedings, this is what I'm talking about, the proceedings of parliament, ought not to be impeached or questioned in any court or place out of parliament. In the United States Constitution, it goes on like each house can determine their own rules of procedure, and the German Constitution says almost the same. The parliament, or in Germany, the Bundestag, provides itself with rules of procedure. It means that the parliament provides itself with a set of rules of procedure. The parliament creates it, and completely independently. This is the case in Hungary, and I'm pretty sure that in other countries, parliaments' autonomy to create their own internal rules is protected by the constitution. Now, what a kind of legal nature these rules of procedures have? What are they? Are they laws? Are they statutes of parliament? Or are they different kinds of legal documents? Because it is different country by country. One possibility, as you can see on the top of my slide, is that they are a statute of parliament. So they are produced as any other statute, any other piece of law, what the parliament creates. This is the case, for example, in Austria or in the Czech Republic, in Slovakia, in a number of Central European countries. The rules of procedure of parliament is a statute, one of the many laws what the parliament produces. It means that it has an external effect, because all statutes of parliament have an external effect. They can bind citizens, they can touch on citizens' rights, and they are not only affecting internal members of parliament. And of course, it is not possible to deviate from a statute. This is very clear. It is a rule that statutes, acts of parliament need to be followed. No exception, no deviation. Let me jump to the second possibility. In some countries, including, for example, Germany, internal rules of parliament are parliamentary decrees. They are not statutes, not acts of parliament. These are a decree, an internal decision of the parliament, having only internal effect. And this means that it's possible to deviate if all parties in parliament agree with that, there is a consensus, it is possible to deviate from these rules, and they can, for one case or for a series of cases, set aside these rules for a justified reason. And there's a limited justiciability also. Of course, courts are everywhere important for protecting laws and also interpreting laws, but parliamentary decrees cannot be interpreted by external courts. I mean, by external, I mean extra-parliamentary. Courts are always external bodies seen from the parliament, seen from inside. And the third category is the autonomous category, if they are not belonging to any of them. Okay, so if they're neither acts of parliament nor internal decisions, but a third category, an autonomous decision. There are countries which chose this direction. Actually, Germany is a better example to the third category, is the internal parliamentary decree. I would bring up the Hungarian example because today, Germany, the rules of procedure, Geschäftsordnung in German, they have their own category, halfway between internal parliamentary decisions and acts of parliament. Now, the legal nature of rules of procedure of parliament is a decisive thing because the justiciability depends on the legal nature. It's a big question, how can I attack these rules, or how can I protect these rules? If they are not respected, where can I go? Can I go to a court, or can I go only to the Speaker of Parliament? Whether or not these rules have external effect or only internal effect. And let me show you first this chart, because I drew up this matrix of possible fora of control against parliamentary rules of procedure. There are decisive factors of justiciability of parliamentary procedures. And these factors are the system of separation of powers, what role parliament and the judiciary plays in the separation of powers, what is the legal nature of House of Rules, and what kind of function we are talking about. Because the international practice shows that the lawmaking function is much protected than other functions of parliament. So if you look at the procedure of lawmaking, all courts and all actors, stakeholders pay very much attention on how laws are made. And I can tell you that the other procedures in the parliament enjoy less attention. And also constitutional courts pay more attention to the lawmaking procedure than other procedures of the parliament. And there is an obvious reason for that. If the lawmaking is bad, then the citizens' rights are in danger. Then there is a bad product of the procedure, which can cause problems in the democracy, in the democratic system. Now, if you look at the chart, you can see 4 places, 4 boxes, because if you seek remedy against decisions of parliamentary procedure, you can either do it inside the parliament, at an internal forum, or at an external forum, typically at a court. Okay, so you can see the first line with Roman 1 and Roman 2, examples to external forum. And below you can see the internal forum 3 and 4, depending on who is looking for remedy. Because external actors, which are not inside parliament, which are not members, those are the citizens, journalists, NGOs, or a simple citizen, they can also seek remedy if the parliamentary procedure is bad. But of course, and that you can see on the right side, in the right column, internal actors should also be given the right to seek remedy. Factions of parliament, political groups of parliament, or the MPs, they are internal actors, as I call them, because they are inside parliament. They are members of parliament. Okay, so these are the four possibilities: internal actors or external actors looking for help if the parliamentary procedure is bad. And the second question, where can you go to? Where can you ask help? Inside parliament, you ask the speaker or any internal organ, or you go out and you look for an external forum, typically a court or the constitutional court. And my assumption is that various jurisdictions can be grouped into this model very well. For example, Hungary has no possibility of external review. No possibility of external review. So this means that number 1 and number 2 is excluded in Hungary. We only have internal fora, a committee, or the house as a whole, the plenary, where you can go as an internal member of parliament, but you can have no remedy, you can do nothing at all if you are a citizen, and the parliamentary procedure infringes in your right. All right, let me show you some grades of judicial activism towards legislative control. Stephen Gartbaum wrote about it, and he distinguished between 4 different scenarios in one of his recent articles. The first stage is the 19th century, when the sovereignty of parliament is unbroken. And in this first case scenario, the parliament stands against the government as a whole, and the individual MPs have the interest to control the government actions. And in this scenario, there are not well-established parliamentary groups backing the government. And in this case, there is no danger or no risk of breaching the parliamentary MPs' rights. In the second scenario, the emerging of parliamentary majority leads to the union, to a power union of the government and the parliamentary majority. This is the modern parliamentary landscape of the 20th century. Politically disciplined parties backing the government, and they have not an interest in controlling the government, but they have an interest to keep the government in office at all costs. Now, this can lead to some kind of internal collisions between opposition and government very strongly, because there is a permanent governmental side and a permanent oppositional side for the term of the government. And this can lead to an emergence of courts. Courts have more to do if rules are not respected. So this is the beginning of the control of parliamentary procedure. If there is a dominant party in the third case scenario, which really not only backs the government, but really dominates the whole political landscape, then the judicial activism also raises. Gartbaum wrote about the Republic of South Africa, because that was where the Constitutional Court exceeded its powers vested by the Constitution and interpreted a more far-reaching competence in this respect, because the Republic of South Africa reached also the fourth scenario, the abuse of power. The parliamentary majority abuses their powers, and also the courts in this case tend to abuse a little bit their powers, to exceed the red line and to interpret more rights in control of the parliament than vested by the constitution. Let me show you some examples of this emerging judicial activism. These examples show that there is a tendency worldwide that courts wish to have a say in controlling parliamentary procedures and not respecting the ancient principle of parliamentary sovereignty and internal procedural autonomy. I just really mentioned them very briefly. I could talk a lot about these cases, but this can be subject of further reading. The first is the Kerins and McGuinness case from Ireland. Miss Kerins, Angela Kerins, an Irish director of a government agency, was invited by a parliamentary committee for a hearing. And she was attacked brutally by the questions. She couldn't receive the questions in advance. She was not able to prepare for the hearing. And during the hearing, she was blamed, she was attacked, she was condemned by the members of parliament, and she was really physically shocked by these proceedings. She needed to be hospitalized after the hearing. She also wanted to commit suicide after this event, which affected her very much. And later on, he went to the court, and she went to the court, I'm sorry, and she argued that this committee of the Irish Parliament, the Public Accounts Committee, the PAC, under the leadership of the committee chair, Mr. McGuinness, infringed on her rights. And everybody was expecting that the court will refuse to deal with this case, because it would mean an infringement in Parliament's internal affairs. But surprisingly, the court, and later on also the Supreme Court of Ireland, condemned the parliamentary committee and said that they breached the rights of a citizen. And said that members of parliament were acting ultra vires, they were acting outside their legal competence. The second example is from Israel, where the Supreme Court struck down an omnibus legislation. Maybe you know omnibus legislation. I know that in Indonesia, it is right now a very common topic. An omnibus legislation is a piece of legislation aiming at modifying several other laws. So practically modifications of lots of laws packed into one bill. And this is a very common way of legislation all over the world in the meantime. But of course, it needs to be done in a fair way. And what happened in Israel was that really very shortly before the last vote, a few hours before the final vote, the government made some changes in this huge package. And it was really physically impossible for all members to understand what is it all about, to have sufficient time to read and study the modifications of these voluminous legislation of many hundred pages. And the Supreme Court said that it is not constitutional. And for the first time in his history, the Israeli Supreme Court, acting as constitutional court, struck down the legislation not because of the internal content, not because that the content is not constitutional, but because the procedure was bad. The procedure of adopting the law was not fair. And This is what a scholar from Israel, Ittai Bar Simontav, calls procedural review. Very many countries only make internal normative control of the content, and they do not do procedural control. And some countries, including Hungary, do semi-procedural control. Semi-procedural means that they look at the procedure also, the court looks at the procedure and looks at the content as well in the same time. Okay, so not only the procedure matters, they only raise procedural problems, they only review the procedure if there is also a problem with the content of the law. This is the semi-procedural control. And I think it is good if a constitutional court enjoys both and has normative control and has also the competence to a procedural control and not only the semi-procedural control. I already mentioned the South African case where the Constitutional Court gradually reached a control position over parliamentary procedures. The motto of this direction can be that special problems call for special remedies. Parliamentary majorities went far in affecting rights of the opposition, and also accordingly the Constitutional Court vindicated ultra vires rights, not explicitly written down in the Constitution, but they interpreted that they have to review the parliamentary procedure. Now the trend is different in Hungary. We don't have a very strong protection of parliamentary procedural rights. I can mention a case from 2003 when the Constitutional Court said that lacking the statutory basis, the committees of inquiry can only hear citizens as witnesses only on a voluntary basis. And the parliament has the obligation to correct this omission, and the parliament has to change legislation in order to say it in a law, in an act of parliament, that citizens need to appear before committees of inquiry. Without this statutory basis, they can appear only on a voluntary basis, which is not enough. But I can tell you that the Hungarian parliament did not make this change, did not correct this omission. What they did is that they deleted that minority initiatives should create committees of inquiry, because before the change, if 1/5 of the members, so if a small minority required, then a committee of inquiry needed to be established automatically without a majority decision to inquire into a certain scandal, inquire into any matter what the opposition wished. Later, this was weakened by saying that the minority of the parliament, 1/5 of the members, only have the right to suggest the establishment of this committee of inquiry and not force the establishment of it. What I wanted just to show you is that there are different tracks in different countries. In Hungary, we don't have a House Rules Court. This is how I call House Rules Court is a forum of the judiciary where the House rules, the rules of procedures can be protected and those debates can be concluded. There is a very effective House Rules Court in Germany where the Constitutional Court has the competence to review parliamentary procedure. On the bottom of my slide, you can see that the European Court of Human Rights after 2005 is increasingly involved in domestic parliamentary procedures. There is an emerging trend in this supranational court that whenever a piece of legislation is questioned by a citizen or by an organization, they not only look at the content of this legislation, but they look at the procedure, how that law was created, whether or not there was a sufficient debate in Parliament, whether or not the dissenting opinions were mentioned in Parliament. They read the diaries of the Parliament, which is a very, very new trend. Courts so far were only responsible for judging the content of a law, the wording, and compare it to the Constitution. But how they were created, how these were done, is a completely new approach. There is a saying in Hungary which goes like, if you like sausage, then never go to a factory where a sausage is produced and never see how it is actually done, because then you will be disgusted, you will not like it anymore. There are people who compare it to parliamentary lawmaking. Those who like laws, parliamentary acts, shouldn't go to Parliament and look how they are actually made, what procedure is actually used sometimes for that. Let me show you very briefly the German model of procedural review. I think this can be made an example to be followed by other countries also. The Constitutional Court has a separate competence called Organstreitverfahren in German, which means in English more or less that a procedure of the debate between different state bodies, between different constitutional bodies. In this procedure, there are two parties before the Constitutional Court, and the reason of the debate is procedure. So if the lawmaking procedure is not respected, then the parliamentary minority can appeal and sue the majority. The minority can appeal the majority, and the petitioner's category is very wide. Even one member of parliament is enlightened to bring the case before the Constitutional Court. This procedure is an interpretative procedure. Constitutional interpretation is happening. It's not like a court case between two parties, one having right at the end and the other is not. No, the Constitutional Court will not say who has right in that particular case, but it will interpret the Constitution and it will guide the debate to a hopefully good, happy ending. And the decisions are very much respected. Practice shows that parliamentary majorities respect decisions of the Constitutional Court, also in this case and also in other cases. This is something which I already mentioned before. I'd like to jump to the bottom of my slide where I show those three models I mentioned before. Substantive review and procedural review are two types of constitutional court procedures. The semi-procedural review means that constitutional courts only look at the procedural errors as a side argument if the substantive review shows problems. In case of semi-procedural review, the Constitutional Court is not allowed to strike down legislation only on procedural reasons. And let me tell you that in countries where there is no Constitutional Court at all, for example, the United Kingdom, there is no semi-procedural review at all. You cannot question anywhere how the British Parliament made acts. If there is a royal assent of the king at the end of lawmaking, you cannot question whether or not it was created in a fair way. There is no constitutional competence of any forum to judge the fairness of the lawmaking procedure. Because the whole English constitution is like, more or less like a gentleman's agreement. It is respected by the parties, but it is not protected by hard legal tools. The second point on the bottom of my slide is the single procedural review at lawmaking. The single procedural review, which means that substantial review and procedural review can be used alone, and they shouldn't be combined. They can be used separately. This is the case also in Hungary. I can tell you that there is not a strong forum in Hungary to protect parliamentary procedure, but the lawmaking procedure is protected very heavily. And the Constitutional Court takes it very seriously. This is the only one parliamentary procedure which is really protected. If there is an error in lawmaking, in the parliamentary phase, let me underline, then the law might be struck down. Before lawmaking procedure, the consultation period is not taken very seriously, but the parliamentary procedure is. And it happened multiple times that the Hungarian Constitutional Court struck down the legislation because the parliamentary rules of procedure were not respected. Let me tell very quickly the third one, the third possibility: procedural review of parliamentary rules in other competencies but legislation. So, for example, what competencies parliaments have besides legislation? This is mostly the control, the parliamentary oversight. And as I mentioned before, the procedure of the oversight is not really protected by constitutional courts. A good example of a good exception is Austria. In Austria, if the minority rights of parliamentary oversight is not respected, then the parliamentary minority can seek remedy at the Constitutional Court. If, for example, the investigative committees are not set up properly, then the minority can ask help from the Constitutional Court. And let me conclude, dear colleagues, with some conclusions. Without telling you very big conclusions, I would like to stress one more, that fair rules have a significance beyond themselves. The court's claim to review parliamentary procedure is a legitimate claim. So I think courts and constitutional courts should be eligible to review parliamentary procedure. But there is no one-size-fits-all approach. Political cultures and government systems are different all over the world. And each country's jurisdiction has to find its own way of controlling parliamentary procedure. Because if there is no domestic remedy inside the country, then some supranational courts may intervene. I told you the example of the European Court of Human Rights, but also the Court of the European Union, the CEU, is also increasingly getting interested in parliamentary procedure. And this maybe can lead us towards a jus commune parliamentiensis, by which I mean a supranational parliamentary law. Maybe in the future, but not now, it could take a lot of time, more decades. Maybe these principles will be protected by a supranational organ, which will judge parliamentary procedures in countries, and where citizens or oppositions can turn if their parliamentary majority doesn't respect the parliamentary procedural rules. Thank you for your attention.
Thank you very much, Professor Szabo, for your lecture about this topic about judiciary role in supervising the legislation. Once again, thank you, Professor Szabo, and I believe this is a very fruitful idea for us here in Indonesia, because I think this is a new topic for us to discuss. Okay, before I open the Q&A session, I would like to ask you, is it okay for you to share your PowerPoints to the participant, Professor Szabo?
Yes, of course, of course. Should I send it to you in email?
Yeah, you can send it to our email, or you can send it also to Dr. Rosa, and she will help
Yes.
To pass the PowerPoint to the participant. Okay. Now I will open the Q&A session. Likewise, for this Q&A session, if you have any question, you can use the raise hand button, or you can open your mic directly. And if you have any difficulty to use a microphone, you also can use the chat box. And if you wanted to ask in Bahasa Indonesia, I will allow it. I will help for the translation in English. Okay, Professor Szabo, we have two questions right now from Adip and Mira. Is anyone, Adip and Mira, still with us here in the Zoom? And if so, I would like to invite Adip first to open your microphone to ask the question directly. Thank you. Are you still with us, Adip? Okay. I think I want to continue to the second questioner, to Mira. Mira, are you still with us? Okay, apparently Mira used the chat box. Let me help to read it to all of the participants and Prof. Szabo. From Mira, as we know, there are many discourses on judicial activism in the practice of the Constitutional Court. I want to ask what the criteria for judicial activism can be said to be overstepping their competency. And okay, maybe that first from Mira, Professor Szabo, about overstepping.
Yes, this is a very interesting and philosophical question. The criteria for judicial activism to overstep their competency. Now, I mentioned the case of South Africa, and in the Republic of South Africa, the Constitutional Court clearly overstepped its competency. But the reason for that was that also the government, also the president did that, crossed a red line and overstepped its competency. And the judges said that even though it is not explicitly said in the Constitution, we have to review and look more into the legislation and the government's activities. And the time showed that this was a good decision from the court, because this helped the powers to be balanced. But of course, it is very, very hard to judge a situation, and it's not always the case. There can be abusive constitutional courts who use their power, who use their activism against the democratic order, cooperating with undemocratic regimes. So legally, I can say that it is always a danger. It is always a risk if any court oversteps its competency, and it should be avoided. And of course, rule of law means that the competence is set in the laws and in the Constitution, and this should be respected. But there can be exceptional times when we don't look only at the formal side of rule of law, not look only at the letters and wording of the law, but also the spirit. And if this spirit requires exceptional cases, of course, in historically justified exceptional cases, then I think some kind of judicial activism needs to be tolerated.
Thank you.
As I see, the question was not about a certain country, but the question was general. I hope I could give some points in my answer.
Yeah. Okay. Is there any follow-up question, Mira, for Professor Szabo? Okay, I believe it's clear. Thank you, Mira. Okay, I recognize a raised hand from Ahmad. Mr. Ahmad, if you may, you can state your question. Thank you. Ahmad,
hello, sir.
Yeah.
Can you hear me?
Yes, you are audible.
Yeah, my name is Ahmed, and thanks for the many thanks for the lecture. My question is quite straightforward. The lecture has to do with judicial control of parliamentary procedure. So over parliamentary procedure. So my question is that based on your lecture, what do you think? Because from what I've seen so far, you made reference to judicial activism. Of course, you also made reference to the principle of separation of power. And in your own opinion, what do you think? How do you think we can reconcile between the concept of separation of power and the right to be heard? Apart from judicial activism, is there any other way to reconcile between those two concepts?
Thank you very much for this question. Again, it is a very theoretical and very good question, a fundamental question, of course, how to reconcile between two principles, between two guiding principles of the democracy, the separation of powers, which helps parliament to be independent, and the other is the fairness, the rule of law, the right to be heard. But of course, there are several other examples for that. I think this balance should be made by the constitution of a nation. So the constitution is a document, which should decide between these two. And the reconciliation is very important, of course, but let me tell you another word, prioritization. So the constitution have to set the priorities. For example, the unwritten English constitution puts parliamentary sovereignty first. And the system is clear. The parliament's independence is first. And even if the parliament does something unfair, it is not a problem. It will not cause a systemic problem there, because the first value should be protected at all costs, and that is parliamentary sovereignty. In other countries, for example, Germany and Hungary, the first is rule of law, which is protected by the constitution, and the constitution should be protected against all other organs. So my answer is that the reconciliation is different country by country, but each country has to choose one value, one democratic value, of course. It should be democratic, not undemocratic. And either the sovereignty of parliament or the sovereignty of constitution can be a foundation to guide the constitutional system.
Okay, is that clear? Mr. Ahmad, do you have any follow-up?
Yeah, it's okay. It's okay. It's a very good one. Thank you very much.
Thank you.
And I see a question from Eduardo Saratoga.
Yeah.
In the chat box.
Yeah. Let me read it, the questions, because actually we have two questions in the chat box, Professor Szabo, but the first one in Bahasa Indonesia. So let me read it, the first one in Bahasa. I will translate it from Adam. So from Adam, what is the difference between a procedural review and substantive review? Is procedural review known at every country who adopt the constitution supremacy, and also known the constitutional review? The first one is from Adam. Is that clear with you, Professor Szabo?
Yes, yes.
Okay. Let me proceed to the question from Eduardo, and because of the time, I'm afraid this will be the last question for our Q&A session. So from Eduardo, may I ask question, do you hear this problem that the sanction of exclusion has already been imposed on some parliamentary of the left-wing party, Die Linke, sorry if I mispronounce it, for having shown sign bearing the name of civilians killed in an air raid by the German army in Afghanistan, on one parliamentary for having denigrated one of his colleagues, and on other for having insulted demonstrator of an opposing political persuasion during the discussion on a draft law on demonstration, in this case, Germany. How do you think to the perspective of judicial control of parliamentary procedure? Thank you, and that will be the last question.
Well, thank you very much for these questions. The first question was about the difference between procedural review and substantial review. Now, I wanted to make it obvious, but I can tell you the difference is in the way how the Constitutional Court is examining the statute. The substantial review is the classic normative review that the Constitutional Court compares the content of the statute of the Act of Parliament with the Constitution, and looks whether or not it goes against the constitutional wording and constitutional principles in substance, in their legal content. The procedural review is not looking in the substance at all. Of course, it's not correct, but maybe to make it clear, it doesn't even open the law, only looks at how it was created, what steps in the procedure were done, and whether or not it respected the parliamentary rules, written or unwritten rules, legal or unlegal rules, internal or external parliamentary rules. I mentioned that there are several types of parliamentary rules of procedure. Okay, so this is the difference between the substance and the procedure. The result of this examination can be similar, and the Constitutional Court in Hungary and in Germany and in other countries can strike down legislation, can annul the legislation, either or procedural reasons or substantial reasons. Now, to go to the second question, I'm afraid I don't know this exact case of the German oppositional party. I know Die Linke. This is a far left party in the German parliament, and they made some kind of demonstration within parliament, as I understand, and they had some kind of punishment. Maybe this is what happened, but I can tell you that this happened also in the Hungarian parliament, that oppositional MPs were fined. Financial fines were imposed on them because they demonstrated by banners and those tables raising up during the parliamentary debates. And the problem was in Hungary that they couldn't go to a court saying that I have a right to show up this banner in parliament and please, Mr. Judge, annul this fine. No, the fines were imposed and there was no remedy against those fines by the speaker anywhere. And this is what the European Court of Human Rights found a problematic thing, that there is no legal remedy against the speaker fining the MPs by their behavior. How I see the prospective judicial control of parliamentary procedures, I see a trend. I see a trend internationally that courts are increasingly active in procedural control. That was the case in Israel. That was the case of Germany, South Africa, and I think also in Hungary this will come.
Okay, thank you, Professor Szabo. Is there any follow-up from Adam and Eduardo? Well, okay, thank you, Eduardo. And I believe this will be the end of our guest lecture series. Once again, thank you very much, Professor Szabo, for your time and for your lecture for today. And I hope you have a good day back in Budapest.
Thank you very much for your attention.
Okay, thank you. And to our participant, thank you once again for attending our event. And don't forget to fill up the registration link at the chat box. Once again, thank you and have a good day.